to the portal.
Right.
So we've got it.
Perfect. So Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of the appointed court agents.
All right, pause right here. The judge is doing something routine but extremely important, assigning counsel and resetting the case. This is where the legal clock slows down so the defense can catch up on discovery. Translation: no trial surprises allowed, at least in theory.
For real court updates, subscribe Judicial Insight.
Considering that the first move is to the state.
I understand. We've had this conversation before.
Conflict of interest. And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today. If that's what you want to do, we'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here.
This is the moment every courtroom viewer should pay attention to. The judge is explaining why self-representation is risky, and not just risky, legally dangerous. Trials are basically rule books stacked on rule books, and without training, even a strong defense can collapse under technical mistakes.
Here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of options, and we'll go over those as well, okay? So
now we're entering what's known as a Ferretta inquiry, the judge's checklist to make sure a defendant knowingly waives their right to an attorney. These questions might sound basic, but they're actually constitutional safeguards.
I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you?
I know we've been accused of.
Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And did you answer out loud?
Here's where tension spikes. The defendant says they don't understand the punishment range, and legally, that's a red flag. You can't waive counsel if you don't grasp what's at stake. In other words, the judge isn't blocking freedom, they're preventing a reversible error.
Just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I have no idea what they're doing.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine, after they listen to the evidence, if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding.
Watch the shift in tone. The judge moves from explanation to decision mode. When a defendant repeatedly shows confusion about basic consequences, the court has a duty to step in, even if the defendant objects.
I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, get ready like you would. Probably it's going to go straight onto a jury. And we'll just get it figured out that way. All right.
For real court updates and legal analysis, subscribe now.
Don't miss the next verdict.